now. All right, I think the recording is switched on now. So a very warm welcome everyone to Large Group 4. This is in continuation of the work we've been doing over the past 2-3 weeks now, looking at the validity of express trusts. And this particular session will continue that, looking at a peculiar type of express trust, really. But let's just remind ourselves first of where we are at, before we get into this. We've already talked about the requirements for setting up a valid trust. Yeah, you need to declare it and then you need to constitute it. And within the declaration of trust, we went through certain requirements, right? The three certainties, the beneficiary principle, the rule against perpetuity, and the beneficiary principle. I've said that already, I think. We talked about formalities, and this week is all about, in one way, it's actually all about the beneficiary principle when you think about it, because we're looking at trusts that are not for the benefit of individuals, but for the fulfillment of a purpose. How are such trusts enforced, if at all? Are they even recognized? And so those are the outcomes that we've got here. I'm just going to highlight the attendance code once more for those of you who've just joined. So what we're going to do, hopefully by the end of this large group, is be confident in our ability to distinguish purpose trusts from trusts for people. That's a critical distinction. More on that shortly. Identify issues of validity that are associated with purpose trusts and explain how they may be overcome. In a few minutes, you'll see that trusts that are set up for purposes have a basic objection to them, and a lot depends on whether that objection can be met. And then finally, once we look at the advantages of charitable trusts compared with non-charitable purpose trusts, we look at the types of scenarios in which a settlor or a testator can get away with setting up a purpose trust and what those exceptions are, why they work. We'll look at that in a fair bit of detail. But I want to start again, as I said, with that very first outcome here, distinguishing purpose trusts from trusts for people. And this is where things can be just a little bit tricky, which is why I want to address it at the outset. It's a difficult distinction to draw. Let's begin with that. Quite often, a trust is expressed in a way that you might think it's a discretionary trust, but when you look long and hard at it, you'll realize that it's actually a trust for purposes. And so we need to ask ourselves, do we really have a way of telling apart a purpose trust from a trust for individuals or trust for people? And I will, of course, I'll dive into that question in a lot of detail in the workshop, but I do want, for present purposes, to remind you of when you might be alarmed by this. Imagine you're examining a declaration of trust. So you look at the certainty of intention, you're satisfied that there's enough there. You look for certainty of subject matter, and you're by and large satisfied that the assets are clear and each beneficiary's entitlement is or will be clear. But when you get to certainty of objects, we've said to you that you need to distinguish between fixed trust and discretionary trusts when you're applying the test for certainty of objects. And that is where you have to, again, apply your mind and maybe realize, if you can, that it is very well possible that what you might be staring at is not a trust for individuals, therefore not a fixed trust or discretionary trust in the traditional sense, but a trust for purposes. And how do we tell that apart, right? So in your student guide, which I would encourage you to please have with you, let me also open up a copy here. In your student guide, we give you some examples, don't we? We give you a few examples that might aid you in distinguishing between trusts for purposes and trusts for individuals. And a lot turns on how comfortable you are with that, with that particular distinction. So if I were to ask you to turn to your student guide and just have a look at the examples we give you at page 2, right? We give you 2 examples there. They're numbered as examples 1 and 2. Example 1 says Sarah Smith transfers £100,000 to trustees to hold on trust for such of my children as attain the age of 21 and if more than one in equal shares. And in example 2, Lee Chen transfers £100,000 to trustees to hold on trust to campaign for an act of parliament banning the sale of tobacco in all forms. Now, if I could just for a minute have this reproduced on this slide here. Bear with me one moment, folks, while I do that, because I think it's important. At the very top of this slide there, I've got those two examples there. Let me just increase the font size. I do not want you to have to squint to see this. All right, let's see. These are the two examples here. Yeah, and I think a good idea, or a good way of progressing with this is to just see whether you can distinguish, these two types of trust. Now, if you look at example one, this is a typical trust that we usually see, right? On trust for such of my children as attain the age of 21, and if more than one in equal shares. So if this is a fixed trust, it's a contingent interest trust, and we know that the beneficiaries are the children of this particular individual, Sarah Smith. If you look at example two, this is a different one, isn't it? Lee Chen transfers £100,000 to trustees to hold on trust to campaign for an act of parliament banning the sale of tobacco in all forms. And the question that arises is, who is the beneficiary of this trust? I mean, presumably, imagine if I went to court. I mean, I don't smoke. Not particularly a fan of smoking either. Been trying to get my partner to quit for about a year or so. But the point is, if I go to court and I say I want to enforce this trust because I'm a strong believer in, doing away with sale of tobacco in all forms, I would lack standing. I would lack an interest here. The court will likely say, or anyone would likely say, that you're not named as a beneficiary of this trust, right? And the primary reason why this one is problematic is because if you look at how it is phrased, to campaign, it's to do something rather than for someone, right? And that's an example, that's a distinction that will appear again and again as we proceed with this. I just want you to focus on that, because if you're looking at an example two type trust here, then you're not looking at a trust for individuals. When you try to apply the certainty of the certainty of objects test for example two, and you go into that analysis, is it a fixed trust, is it a discretionary trust, that's where the analysis just falls apart, doesn't it? Because this is neither. You can't say this is fixed. You can't say this is discretionary. This is a purpose trust. But let's, get into this in a bit more detail. I'm going to open up activity one on this slide here, which gives you 4 declarations of trust, and it asks you to classify which one or more of these are purpose trusts. So can I just ask you, let's just do with well, let's deal with each of them one by one. Let's start with the first one. £100,000 on trust for such residents of Cheshire as my trustees think are most deserving. Is this a purpose trust or a fixed trust or discretionary trust, either of the two? Anyone? Rebecca, thanks, Rebecca. Thanks, Natalia. Rebecca and Natalia said discretionary trust. I'm just going to give it a few more seconds in case somebody else is also writing thing. Thanks, Anissa. Yeah, discretionary. I mean, I agree with you, folks. I think that this is a discretionary trust, not a purpose trust. It is for the residents of Cheshire. Yeah, that's those are the terms of the trust there. So good. Whether it's fixed or discretionary is a bit debatable, but I can see why you're saying it's discretionary. So I'm not going to say more on that yet. Let's look at the second one. £50,000 on trust to promote good manners in Cheshire. Is that a purpose trust or a fixed or discretionary trust? Maxine has beaten Anissa by a millisecond there to say purpose trust first. Anissa also says purpose trust. You're both absolutely right. Thanks, Natalia. You're both absolutely correct. That is indeed a purpose trust, right? Because you'll see here, it's not for anyone in Cheshire. It's to actually do something in Cheshire. That's the key difference here. And then the third one, £25,000 on trust to be divided between my relatives equally. What type of trust is this? Thanks for that, Rebecca. Maxine, it is indeed a fixed trust, so it's not a purpose trust here. Yeah, thanks, Natalia. Right, so this is, you'll see here, It's for the relatives equally. They are the beneficiaries, just like in the first one, it was residents of Cheshire who were the beneficiaries. And then the final one there, £10,000 on trust to encourage reading among my relatives. Thanks, Anita. Right, that's you've got there first. Thanks, Rebecca Maxine. That's absolutely correct. This one is a purpose trust. You'll appreciate that this is a slightly more it's a slightly more nuanced one, if I may, because it's not that you can't identify the people who will benefit from it. My relatives will benefit from it, but the point is, the trustees are only allowed to use it to encourage reading. And so if one of my relatives were to come up and say, give me, £1,000, I want to use it for my own benefit, they'll say, no, right, we can only use it to promote or encourage reading. The point is, it still is a purpose trust. And so, yeah, I think as you do more of these, you'll be confident in your ability to spot them and how you deal with purpose trust. The way to deal with trust for purposes, because like I said, when you're analyzing the validity of a trust, you get to certainty of objects. If it's a purpose trust, what do you do? Well, the first thing you do is you state something that is just a little bit difficult for most people to digest, which is that by default, purpose trusts are invalid. Purpose trusts are, as a general rule, void for four reasons. And those four reasons are set out in this slide. I'll develop them each one by one. The first one here, that the beneficiary principle doesn't comply with that. Doesn't comply with the requirement of certainty, although that's a bit suspect. Doesn't meet the rule against inalienability of capital. Now that's the second perpetuity rule that I had been promising would come up. And then finally, capriciousness can also sometimes be an objection. But let's just develop each of these one by one. The beneficiary principle is perhaps by far the single biggest objection to a purpose trust. Yeah, and you'll see here we've looked at this in unit 2 when you looked at the requirements for a valid declaration of trust, and we talk about I think a good case to start with here would be Maurice and Bishop of Durham. Yeah. Note it's Maurice and not Morris, two different names, but nothing really turns on that for present purposes. In Maurice, and we give you the extract from Maurice, don't we, in the student guide. I'm just going to read off that if you don't mind, because I think it's a very good explanation of why purpose trusts are generally frowned upon. Because in that case, Sir William Grant said that there can be no trust over which this court will for an uncontrollable power of disposition would be ownership and not a trust. Every trust must have a definite object. There must be somebody in whose favor the court can decree performance. That last bit here, and I know some of you in the workshop have been quoting that, which is good to see. I'm just going to reproduce that here on this slide, right? This is what was said in Maurice and Bishop of Durham. Spare me one moment while I do that. Oops, not that. Yep, so you'll see here, let me just zoom out a bit, sorry about that. Every trust must have a definite object. There must be somebody in whose favor the court can decree performance. This is the key objection. Why do trusts need beneficiaries? It goes back to that very definition. There has to be a duty imposed on a trustee. And if there's a duty imposed on a trustee, then there needs to be some form of there needs to be someone who can enforce that obligation. That's the key point that you might want to keep in mind here, right? So that is the idea here of why this happens the way it does, why the beneficiary principle exists in the first place. It's central to the very definition of a trust, right? The long and short of it is that any attempt to set up a trust without beneficiaries will therefore be void. And the beneficiaries must be either a human being or even a company, right? That might work. Anyone who can actually go to court, and you'll guess here that by default, Animals can't go to court. Trees can't go to court. Unfulfilled promises of promoting good manners can't go to court. So those are all practical concerns that hold things back. We also talk about, we give you a couple of examples in your student guide, don't we? We give you the example of re Astors, where the trust was set up for the maintenance of good understanding, sympathy, and cooperation between nations, and the preservation of the independence and integrity of newspapers. And this was held to be void, right? The trust in re Astor was held to be void because there was no ascertainable beneficiary who could enforce the trust. The other one that we mentioned in your student guide is Re Shaw, right? In Re Shaw, they the testator was a famous playwright, George Bernard Shaw, who gave the residue of his trust to be applied towards establishing a 40-letter alphabet in place of the present 26-letter alphabet. Well, he wanted more than that. He wanted his play, Androcles and the Lion, to be translated into that 40-letter alphabet. What he had in mind, I don't know, because we already, I can sense it, right? I have a 5-year-old who struggle to explain to him why BUT is put, but BUT is not but. But the idea is, there's merit to having a 40-letter alphabet. But the reason why the trust didn't work is because, once again, there were no ascertainable beneficiaries. Who would benefit from a 40-letter alphabet? Who would have that benefit to enable them to go to court to have it enforced? That's sort of the problem that stood in the court's way there, and this was therefore held to be void. Yeah. I'm going to very briefly talk about certainty here. I think it's the slide in front of you. That's the second objection to a purpose trust. Yeah, you'll see here that it says that the description of the purpose and any beneficiaries must be certain, and this is simply to enable the trustees what they should do with the money. By default, purpose trusts are of a nature that they will be phrased in a way that doesn't quite explain what a person has to do with the money in that sense. But yeah, the point being here that it's the lack of clarity as to who the trustees hold it for, that sort of is the chief objection, if you will. The third objection we talked about is the rule against inalienability of trust capital. Now, you will recall from large group 2 that we said, as a matter of policy, trusts that benefit individuals cannot go on forever. Trusts for beneficiaries, in fact, are void, for human beneficiaries are void, if they don't comply with the rule against remoteness of vesting, which is the perpetuity rule that applies to trusts for individuals. And that rule is 125 years is within which a contingent interest must vest. So the long and short of it is that trusts for individuals cannot go on for longer than 125 years. In the same way, there are rules as to how long trusts for a purpose can go on. You will see that purpose trusts can be either charitable or non-charitable. We'll get to that in a minute when we look at the exceptions. But just to give you a very brief overview of it, if a purpose trust is charitable, then it can go on forever. If that's because charities are for the greater good of the community. If a purpose trust is non-charitable, then to be valid, it needs to have a limited duration. And this limited duration rule is what we call the rule against inalienability of capital. The rule against inalienability is, again, reproduced in your student guide, where we ask you to look at it in the following terms, right? We say to you that the purpose trust is void if it renders capital inalienable for a period longer than 21 years. And therefore, any purpose trust that is not charitable will be void for that particular reason. There are, of course, two ways around that problem. One is to expressly state in the trust declaration that it is not going to last longer than 21 years. The other, if you don't do that, then you might just say, well, are the trustees able to spend all the capital on the purpose and thereby end the trust at any time? If so, then of course that too will cause the rule to be complied with. So you'll see here it's a sort of a two-part step or two-stage analysis, if you will. If I want to create a non-charitable purpose trust that does not offend, yeah, I'll just do that again, Anisa. If I want to create a trust for non-charitable purposes, and I want it to comply with the rule against inalienability of capital, I have to do one of two things. Number one, I can either expressly state in my trust declaration that this will happen for 21 years only. So, for example, a trust to promote good manners amongst my relatives for 21 years. That's fine. That's confined to a 21-year period, right? Um, the other thing I can do, if I don't confine it to a 21-year period, I can still comply with the rule against inalienability of capital if I have permitted my trustees to spend all the capital at once and end the trust at any time. And this will become clearer as we apply it in various scenarios here. If you look at Li Chen's trust again, that example we looked at from your student guide, right? Li Chen had given £100,000 on trust to campaign for an act of parliament banning the sale of tobacco. Now you'll realize that this is actually a non-charitable purpose. And the trust capital consists of the trust property. Here, the trust capital is £100,000, right? The trustees will invest it in shares, in building society accounts, wherever, but it is still trust capital. Now, in order for this to be valid, in order for this purpose trust to not offend the rule against inalienability of capital, either the trust's terms must allow the trustees to spend all the capital at once, or the duration of the trust must be limited to 21 years. Now, when you apply that to these facts, right, the two-part question that you say, or that you sort of consider, you'll see that this particular trust is likely to be valid because the duration is not expressly limited to 21 years, but the trustees can spend the capital on the campaign. That's sort of the thing here. Contrast this with things that are of a recurring expense, or of a recurring nature, sorry, I should say, right? If I say £100,000 to maintain my garden, and I don't say anything else, you see that that will offend the rule against inalienability of capital because maintaining a garden is a recurring expense. My trustees cannot spend the capital at once because they have to, they have to do it every day. You can't just maintain a garden today and think that you never have to work on it again. It's a recurring expense. And so if I really did want to provide for maintenance of my garden, I would have to state that it is confined to a 21-year period. Otherwise, it would not work. More on this as we get into the workshop, by the way, right? So for present purposes, just note that this is the objection to deal with. The final objection is capriciousness, right? Some purpose trusts are just quite bizarre, like Brown and Burdett, where the testatrix left her house to on trust to block up the windows and doors for 21 years, and this was too capricious, right? And the courts will generally not allow purpose trusts that are capricious and that serve no useful, no useful purpose really. Another interesting one was where there was a trust where women wanted to have to have people collect alms from her grave, and that was held to be capricious as well as problematic for a variety of reasons. It was just so bizarre and so arbitrary that it was held to be capricious. But let's take a step back here and remind ourselves of why we're talking about these things to begin with. We're talking about these things because these are four objections to purpose trusts, right? Four reasons why trusts for purposes are not considered to be valid. The upshot is, of course, that if a purpose trust does meet these four objections, then maybe it will be recognized. But it's an uphill battle, you'll see, because there's a lot to be done here in order to meet these objections. As I keep saying, the most significant objection remains the beneficiary principle, right? So this is the one that you should be focusing on the most, if I were to put it in a hierarchical way. But more on that as we get now into the exceptions to that general rule that you cannot set up or create, excuse me, a trust for purposes. Um, and that brings me to the first exception. The first exception to the general rule that you cannot create a trust for purposes is that if your purpose is charitable, you can actually set it up. and that is protected by the law. Of course, the key point is, what do we mean by that word charitable? And that has a legal definition, which we'll get to shortly. But when I say that word charity or charitable, what's the first charity that comes to your mind? Just for my consumption, I'm doing a mini social experiment of sort. When I say the word charity, what comes to mind? Which organization comes to mind first? Red Cross, yeah. Thanks, Maxine. That's actually one that a lot of people say for the very first time. Yeah. Any other? Nobody else has heard of charity? Mahad says Dawat-e Islami. All right, okay. That's a religious one, I suppose. Yeah. Um, Dawat-e Islami. Yeah. All right, good. Thanks, Mahad. Right. Any other that comes to mind? Cancer Research, yeah. Bill Gates Foundation, all right. Judy, thanks, Anissa. Yeah. Again, but Bill Gates Foundation probably more so because if it's North American origins. Cancer Research UK, of course, quite prevalent. But yeah, you'll see here, USAID. Is USAID a charity? I'll have to check on that. In my view, I'll have to check that actually. I don't think it's a registered charity in the UK, but thanks for sharing it out the list, Judy. I assure you, this is a rabbit hole I will go down under tonight for sure, right? But I'll get back to you on that one. Um, the point is that all of these charities that you've mentioned have all been set up for a purpose, right? They all serve one purpose or the other. So, for example, Anissa says cancer research. Cancer research has a specific purpose, in fact, related to the disease of cancer, right? It's the same with the others that you mentioned there, Dawat-e Islami, Red Cross. They're all there for a particular purpose. And the trust is perhaps the most suitable vehicle for giving effect to charitable purposes, right? Um, if you create a charitable trust, the trustees have to register that with the Charity Commission, and that register is open to public inspection. The Charity Commission monitors all charities, and the trustees have to submit annual reports to the Charity Commission. The Commission can actually intervene and can strike off trustees. They can even take the charity off the register and so on. What I'd like you to do, keeping in mind that my slide here says activity 2, I want you to have a look at this extract from the relevant data available on the Charity Commission's website on the Joseph Rowntree Charitable Trust, right? I want you to give me 3 reasons why this trust would be void if it had not been charitable, right? You see here the charitable objects are the income to be applied. I'm reading from this little portion here. The income to be applied for such charitable purposes or objects and in such manner as the trustee shall in their uncontrolled discretion think fit, right? So I think it's reproduced here as well in clearer font. Yeah. 3 reasons why this trust would be void if it were not charitable. If you go back to the objections that we looked at or we considered just a few minutes ago, if this were not a charitable trust, what would the problem? Yeah, very good, Mahad. That's a very good start, and thanks, Anissa. That's also correct. Let's put both of them here on the slide here. The first would be the beneficiary principle. Is Yeah, thanks, Natalia. You're absolutely correct, right? Is not met, right? Because there are no ascertainable beneficiaries here, right? That's the first. The second point is what Anissa says there about there being no time limit. I would say that, let's just take that a step further. It's the rule against inalienability of capital that Anissa has in mind there. Maha, that's absolutely correct. Certainty is indeed the third objection. We'll just get to that shortly. I want to address the time limit first. I say that even if it's not confined to a 21-year period, that alone is not what's fatal, because a purpose trust can still be valid if it is not confined to a 21-year period. Yeah, absolutely, Mahad. It is indeed the income, right? So that's the problem here, that it offends the rule against inalienability of capital because it is neither confined to 21 years nor does it allow trustees to spend the capital at once. That's the key point here that I want you to remember, right? That when you're applying the rule against inalienability of capital. Look for a time limit. If there's no time limit, ask yourselves, can the trustee spend the capital at once? Here they can't because it says income to be applied. And that's fatal. Income means you can't touch the capital. You can only look at or touch the income. And then the final one here is certainty, as Mahad said, right? The purpose here is quite uncertain. Let me take the question. So rent, Mahad is asking, so rent from a property cannot be made subject of a trust. It can indeed, Mahad, right? Rent from a property can indeed be made subject of a trust. Now, I think the question you have in mind is in relation to trusts for individuals. I can create a trust over the income generated from my real estate, provided that the contingency, if any, vests within 125 years, right? That's for purpose for persons. For purposes, the rule is different. For purposes, the rule is that you cannot create a trust that goes beyond 21 years. If I wanted to create a purpose trust over the rent from my property, I can do that, but I'll have to confine it to a 21-year period. That seems to be the remit of this particular rule. Yeah. Now, the point here, no worries. The point here is that despite these three objections, the Joseph Rowntree Trust is a valid trust because it is charitable. And that's the magic, that's the benefit that you get. There are considerable advantages if you are declared charitable, right? There are significant advantages to be gained. And let's look at that. What are the benefits of being declared or deemed charitable for purposes of the law, right? I mean, we've got here, we're talking about tax reliefs in the sense of donations and other income of charities. That is indeed correct. But if you look at other things as well, let me just put a couple of things here so that we can all deal with them together. I mean, the first, of course, is that they are exempt from the beneficiary principle. Yeah, that's a crucial one, that charities or charitable trusts are exempt from the beneficiary principle. Or what that means is that they will be, they'll likely be enforced by the Attorney General. Because they are so beneficial to society, the government has incentive to actually have it enforced through the Attorney General. And the Charity Commission, of course, is the overall regulator there. The other one that I should point out here for you is that charities are also exempt from the rule against inalienability of capital. Charities can exist forever. The Attorney General, so Mahad, the Attorney General is the principal law officer of the country, right? And the Attorney General, well, he's the government's lawyer essentially, and it is the Attorney General's prerogative to have charitable trusts enforced. Typically, he will do this either on the Charity Commission's instructions or through the government's instructions, right? One or the other. But there is a bit of nuance here that I don't want to go into because it's not a part of your course. So remember, the objection is there is nobody to the charitable purpose trusts do not comply with beneficiary principle, right? Because there's no beneficiary there, no human being to benefit from it. The answer to that is that charities, despite their non-compliance with the beneficiary principle, can be enforced by the Attorney General. So the problem, the mischief of the beneficiary principle is not really attracted in that sense. Yeah, that's how they work around that. So it's the Attorney General who's got the power to have it enforced. I was also saying there that the second, of course, advantage being that they're exempt from the rule against inalienability of capital. Can anyone guess how old the oldest charity is? Without Googling it, please. When do you think the first charity was set up? or at least the oldest one that's still in existence today, the oldest charity that still exists today. World World War? Really? Is that after World War? 200 years ago? No, Anissa, think bigger. 125. Maxine, think longer. The oldest living charity, and by living I mean that still is running, is actually the King's School Canterbury. No, Anissa, you're still about half a century off. Well, 500 years off. The King's School Canterbury was set up in 597 AD, right? 597 AD. That's when the King's School in Canterbury was set up. I actually went there about nearly a year ago now. I didn't go there, go to school there. I actually went to visit. They've sort of redone a bit of it, so it doesn't look as old, but it is indeed still standing on its feet. Yeah, the King's School Canterbury. That's the oldest charity. So the point being that unlike trusts for individuals, which must come to a logical end, charities can and often do exist forever, because the purposes are such that they can't be fulfilled quite, in any definite amount of time. The third to keep in mind is that charities are exempt or exempt from certainty of objects requirement. As to say, exempt from the requirement of certainty of objects. To be more accurate, I'm just writing this down while I speak. Exempt from the requirement of certainty of objects. So that's the third sort of advantage, if you will, that you get if you have a if you're looking at a charitable purpose trust. You'll see here that trusts for charitable purposes can have vague purposes. Provided that the purposes themselves are charitable, the trust will not be invalid, as you've seen with the Roundtree Trust just now. The Charity Commission can actually help in advising how to apply the trust fund. So the long and short of it, of course, is that if you're acting for a client who wants to create a purpose trust which offends the beneficiary principle, or the rule against inalienability, or you think that the purpose is uncertain, try to see if you can make the purpose that make the trust charitable, because that will allow you to get a clean chit for all those three things there, for the beneficiary principle, the rule against inalienability, and the requirement of certainty of objects. I want to spend just a bit of time on tax reliefs, because this is a big one, right? Gifts to charity and the creation of charitable trusts are usually exempt from tax. Now I'm emphasizing usually because there are exceptions to this, right? If a testator creates a charitable trust in his will, that part of his estate will be exempt from inheritance tax. Once the trust has been set up, you can actually attract donations from the public, and the charity can claim the income tax on such donations or contributions, and actually get that as well. Apart from donations, income from investing the charity's trust fund is exempt from tax. Now, it is estimated that tax reliefs for charities cost the Treasury in excess of £5 billion a year. And the taxpayer also pays for the Charity Commission. The government also allocates money as support packages for charities. Um, you see, a lot of people make a big deal out of this, right? They argue that, well, why should the taxpayer have to fund charities? The short answer to that is that even though charities might not directly, you know, be contributing one way or the other, they do provide some benefit to the public as a whole. But the other side of it, which merits equal attention, is the fact that everyone, in one form or the other, is funding charities. So the tax you pay is actually being used to fund charities because of, let's say, state subsidies. And it is for this reason, it's because these advantages are so deep and so many of them, that it's not easy to be declared charitable. There are a number of things that need to be met in order for you to get the benefit of all of these advantages. There is one more thing in your student guide, for instance, which we talk about. Sorry, not here. That's the doctrine of CPRE. That's another advantage. CPRE, CY, and then there's PRES. The E is with an accent at the top. CPRE is another advantage of charitable trust because it gives you just some insight into how privileged charitable gifts can be. If a will contains a legacy to a beneficiary, and that beneficiary dies before the testator. We've talked about this. The doctrine of lapse kicks in. The gift will quite literally lapse. But when the same thing happens to a charitable legacy, the charitable legacy will not lapse. For example, if I leave something to charity, let's say I leave something to a named charity, but at the date of my death, that named charity is no longer in existence, it is actually possible for that to be distributed amongst a different charity if my will disclose a general charitable intention. Now, just note that you have to, yeah, I'll repeat that one more time. Um, Maxine, the idea is that trust for individuals, right, or a gift to an individual made in a will is going to lapse if the beneficiary dies before the testator. Yeah. So if I leave something to X in my will, but X dies before me, the gift in favor of X will lapse. If I leave something to a charity in my will, let's say I leave something to a charity called, you know, ABC charity. I mean, for lack of creativity at the moment, if I leave something to a named charity, which no longer exists at the date of my death. Let's suppose it just wrapped up or wound up about 5 days before my death. That gift to that charity will not lapse, at least not automatically. It is possible for the Charity Commission to actually develop or devise a scheme whereby my gift will now go to another charity that has a purpose similar to my intended charity. Right now, the reason why I am not, dwelling too much on this is because you're not going to be examined on the CPRE doctrine. You just need to be aware of it. You don't need to actually apply it. There's actually a whole set of rules as to when CPRE is available. For present purposes, we are just looking at the advantages of charitable trusts, and CPRE is one of them, right? The idea that you get this benefit if your purpose is charitable and the charity no longer exists. It's another advantage to be had. And that brings us to the big question, the actual question that you should be focusing on, which is how to create a charitable trust. What must you do to get these really terrific sounding benefits? How do you go? So I'm going to read Natalia's question. How do you call a person who makes a charitable purpose trust? Is it yeah, Natalia, if you're setting it up during your lifetime, you'd be a settlor. If you're doing it through your will, you'd be a testator, right? The terminology is not different for anyone who's setting up a charitable trust. The same terminology as for any other type of express trust, settlor or testator, yeah? Let's look at how you can actually then create a charitable trust. There's three basic requirements to be met. The Charities Act of 2011, by the way, is the governing statute. That's the leading statute today. And that gives you the three requirements here that are on the slide in front of you. The point is that the Charities Act 2011 is not a new thing. It simply consolidates the law that existed prior to 2011, and charity laws existed for centuries. So previous case law is still very relevant. The Charity Commission today will make most decisions on whether a trust or other body is charitable, and you can appeal against the Charity Commission's decision to the courts. But we'll just get into this one by one. The three requirements are, number one, that the trust must be for a charitable purpose. That's Section 3 of the Charities Act 2011. The purpose must be exclusively charitable, right? That is Section 1, subsection 1, paragraph A of the 2011 Act. And then finally, it must be for a public benefit. Now, I'm going to develop each of these one by one. For charitable purposes, that first requirement, if you go to the very end of your student guide, we give you Section 3 of the Charities Act in full, right? And when you look at Section 3, you'll see that it contains 13 heads of charity, which the law recognizes. In fact, if you don't mind, I'll just briefly share my screen with you, where I've got the statute sort of put up. Just bear with me one moment. I know I can figure out how to do this. Yeah. So can you please use the raise hand function to confirm that you can hear me? Sorry, that you can see my screen. Yeah. Okay, great. That you can see my screen. Yeah. Okay, great. This is section 3 of the Charities Act, and you'll see here, paragraph A is where it begins: prevention or relief of poverty, the advancement of religion, the advancement of education, and the advancement of religion. These were the original big three, if you will. They were historically the first heads of charity ever to be recognized, right? Even before the 2011 Act, as I said. The rest of them, the remaining 9 here, are were incrementally added. And then the 13th is a residual category, any other purpose that is analogous to these original 12 purposes, if you will. So quite literally, the very first thing you'll ever do when you're trying to consider whether a purpose is charitable or not is you'll go to that list there. You'll go to these 13 heads of charity and see, does my purpose fall within one or more of this, right? These heads of charity. The main ones, like I said, are poverty, education, religion, and health. I'll focus on health. Health is not one of the original 3, but it still is a common one. These are the ones I'd ask you to focus on in your reading as well. You don't need to know the detail about the others really. So that's section 3 of the Charities Act 2011. Sorry, let me just go back to my slides now, if you don't mind. Uh, Bear with me one moment. Where were we? All right, here we go. The requirement of exclusivity is simply that if you want to create a trust for charitable purposes, it has to be for charitable purposes only. You cannot have a mixture of charitable and non-charitable purposes. If there is even a slight possibility of a declaration of trust allowing the trustees to pursue a non-charitable purpose in addition to hundreds of charitable purposes, the entire trust gets contaminated and will be void, or will not be charitable, essentially, right? That's the key point here. So it has to be exclusively charitable. Public benefit. This has 2 limbs to it, actually. It's perhaps the most significant requirement when it comes to charitable status. And this comes from section 4, section 4 more generally. The 2 limbs to the public benefit test are, as the word suggests, there's a benefit aspect and then there's a public aspect. And both of those aspects need to be met in order for a purpose to be deemed charitable, right? We'll actually go into what the precise test under each head of charity for public benefit really is. Right. For present purposes, just note that there'll be no presumption of of benefit. Prior to the 2011 Act, it used to be thought that some charitable purposes will be presumed to be beneficial, but now that is no longer so. You have to establish that there is a clear benefit and no detriment to be gained out of a particular charitable purpose. Um, an example of a case where a trust was deemed not to be charitable because of the fact that it had no benefit to it is a case called Re Hamiltonberg. I'm not going to write it down because you don't need to know the name. It might be there in the student guide either way. But in Hamiltonberg, they wanted to set up a trust to establish a college for training spiritualist mediums. And there was just no benefit there. Similarly, in a case called Repinion, one of my all-time favorite cases, the testator wanted to have his house and its contents preserved as a museum, but expert evidence suggested that his collection was actually of no value, and the judge described it as a mass of junk in the judgment and said that there is no reason why anyone should have to bear with it right there. So that I'm going to write the name down for you, Maxine, but like I said, you don't need to know the names indeed, the names of the cases here. It's just to illustrate for you that these are this is the idea here, that the purpose has to be for the benefit of an individual. So that's the benefit aspect, right? There is also a public aspect, which is perhaps trickier, because the requirement here is, when you create a purpose trust, it can either be for the benefit of the world at large, which is fine, or it can be for a section of the public. Now, this is where things get tricky when it comes to charitable purposes, right? Because when you're creating a trust not for the world at large, but for a select community, the question is that a sufficient section of the public? That will depend, or that will determine whether or not the public benefit requirement is satisfied. Right. So, for example, is there sufficient public benefit if the trust only offers benefits to the blind or to children or to residents of a town or to employees of a particular company, right? Then you'll see here you'll have to ask, what does a group have to be in order to constitute a sufficient section of the public? And the test for that varies from one head of charity to another. So what we're going to do for the next few minutes now is actually look at those other heads of charity. We'll also take a break, in between. But for present purposes, let's just look at these heads of charity one by one to see how the law has developed with, in line with them. The prevention or relief of poverty, that's the first one that it's in section 3, subsection 1, paragraph A. Let me write that down for you. Right, this is the paragraph here, prevention or relief of poverty. Now, this is, of course, a head of charity that has been recognized since time immemorial, really. What does poverty really mean? The key point here about poverty is defined in that case called Ricolthurst, which is there in your student guide. And Ricolthurst defines poverty in the following terms, right? It says persons who have to go short in the ordinary acceptation of that term, due regard being had to their status in life and so forth. Now, what the key point about poverty here is that it does not mean that you have to be utterly destitute, right? Destitution is not what's needed. If you've had to go short in life, you will fit the description of being in poverty. So it's a fairly generous definition. Let's put it that way. That's section 3, subsection 1, paragraph A. In order for it to be for a purpose trust for relieving poverty to be charitable, it must also be exclusively charitable. So the trust must only benefit people who are poor. If it benefits people who are not poor, then that will not be charitable. There can be no benefit to other types of people if you want to create a valid trust for prevention and relief of poverty. The tricky bit, of course, is public benefit. Now, when it comes to public benefit, sorry, just give me 1 second back here. Before I get into this, the public benefit test requirement, rather, is very relaxed, or most relaxed, when it comes to poverty. I'm just going to take Mahad's question now. Let me just see what he says. What exactly would go short mean? Well, it's a good question, but the judge deliberately didn't give us a definition for that. He simply sort of qualified that by saying those have to go short in the ordinary acceptation of that term. He's expecting us to know it when we see it, right? But unfortunately, there's been no case to help us decide what we mean by go short. The basic point is you don't have to be utterly destitute or utterly without any means whatsoever to be impoverished. You can be deemed impoverished if you simply don't have enough to meet your day-to-day expenses, right? So there's no sort of exact definition for that, I'm afraid. That's just how it's been defined. Going back to the public benefit requirement, I just said to you that it's the most relaxed when it comes to poverty. And here's why. In your student guide, we tell you that the settlor's relations amount to a sufficient section of the public when it comes to trust for the relief of poverty. Now, that is quite glaring when you think about it. I can, in other words, create a trust to relieve poverty amongst my relatives. That's fine, right? That there's no problem with public benefit here. The only thing to look out for is the test laid down in Re Scarisbrick, 1951. In Re Scarisbrick, the test that was laid down was that you need to have your trust phrased in a way that it relieves poverty amongst a class of persons rather than being construed as a gift to individuals. right? And this is where the key point of the examples here given in the slide in front of you come up, right? Compare these two examples. A trust to relieve poverty among my relatives A, B, and C. This will not satisfy the public benefit test because of the test laid down, because of the law laid down in Rees-Scarsbrick. Yeah, let me just write this down on this slide if you don't mind. No public benefit because of the law laid down in Rees-Scarsbrick. You'll see here the reason why it's not going to meet that test is because this declaration actually names relatives A, B, and C. That is not going to work. By contrast, if you look at the second example there, a trust to relieve poverty among my issue or my descendants or my relatives. Now that is a class of objects, it's a class of individuals that you've identified, and this will be charitable. There's a case called Re-Segelman. I'm going to write that down here. It might just help you. Re-Segelman from 1996, which suggests that if the class is capable of expansion, it is likely to be to satisfy the public benefit requirement. Again, note that this is just for prevention and relief of poverty. It's a very relaxed test. The test for other heads of charity is far more stringent. But this is where we are at right now, right? Trusts for poor relatives, for poor relations will satisfy the public benefit requirement, even though it's such a small or likely to be such a tiny class of individuals. And for the longest of time, it was thought that these decisions from the 50s, if you look at Scarsbrick, look at Coulter's, I think it's even older than that. That's also from the 50s, actually. For the longest of time, it was thought that these would be overruled. And there was an opportunity to have this reviewed when you had a case called Attorney General versus Charity Commission being heard. But in those cases, in Attorney General and Charity Commission from 2011, the upper tribunal confirmed that trusts to relieve poverty amongst relatives, amongst employees of the same employer, amongst members of a club or members of a society, all of them are valid charitable purpose trusts. They will all satisfy the public benefit requirement, right? So that's what AG and Charity Commission does. AG and Charity Commission 2011 reaffirms that the poor relations cases are valid. So that's prevention and relief. Just before we take our break, can we quickly have a look at activity 3, please? Right, again, just to see if we're comfortable with prevention or relief of poverty as a head of charity. This is going to give you good practice here. Just have a look at this. It's is a trust of £300,000 to provide a hostel for asylum seekers in London. Yeah, Maxine, don't worry. I'll be on the previous slide when you go on the break. All right. Is a trust to give of £300,000 to uh, sorry, I'm just going to go back a minute because Natalia also has a question. Reaffirms what? Reaffirms that the poor relations cases or the poor relatives cases are valid. Yeah, that's what AG and Charity Commission holds. Natalia, just for your benefit, I'm going to go back to the next slide, and during our break, we'll go back to this one. Yeah. This is the activity I want you to do. Is a trust of £300,000 to provide a hostel for asylum seekers in London likely to be charitable? And the way you do this is, of course, you're going to try and fill out the right-hand column of the table. Let's do this together before we go for the break. Is there a charitable purpose here? Mahad says yes. Anisa also says yes, as does Maxine. All right, what head of charity are we looking at? Should be fairly obvious, but which head of charity would this fall within? Judy says yes. Anissa says asylum. So where would that be? Asylum seekers, but where would it fall? Is it advancement of education? Is it advancement of religion? Is it something else? Public. Yeah, thanks, Rebecca. Thanks, Mahat. Poverty. So that's the first step. It's a fairly straightforward step, right? Not advancement of poverty, relief of poverty, right? So yes, this falls within relief of poverty, prevention and relief of poverty. Yeah, prevention and relief of poverty or relief of poverty under section 3(1)(a) of the Charities Act 2011, right? Um, Again, there is, of course, something to be said about the fact that not all asylum seekers are likely to be poor, but the fact that they've used a hostel as the mode of accommodation, it's a fairly basic kind of accommodation, isn't it? A hostel is low cost accommodation, which only the needy would resort to. This is, in fact, something that was acknowledged in a case called Re Niazi, Re Niazi's will trusts from 1978. I'll just put that here on the side. The case that I've just cited here confirms that hostel, the word or the idea of hostel accommodation is meant to connote modest accommodation, right? Accommodation that is for those who are on a low income. So that's why this is likely to be a charitable purpose in the sense that it is for prevention and relief of poverty. Now, just because it falls within one of the heads of charity does not mean that it is charitable. It only means that it has satisfied the first requirement. We also have to look at the second and third requirements here. Is it exclusively charitable? In other words, can people who are not poor benefit from this? I'll rephrase the question. Is the purpose exclusively charitable? If you could answer that for me again. Sorry, I know I probably switched around my question. Is the purpose exclusively charitable? Anissa says no. Maxine says no. All right, if you can make out a case for that. Mahad says yes. For those of you who think no, why is it not exclusively charitable in your view? Natalia says not all asylum seekers would be poor. I completely agree with that, Natalia. But the nature of accommodation here, it's hostel accommodation. An asylum seeker who has resources will not want to put up in a hostel where they have to share so many facilities, right? So it's for that reason that you can probably say that it is exclusively charitable here. I'm going to say probably because the nature, yeah, quite so, Judy. The wealthy would not opt to live in hostels because the nature of the accommodation is geared towards those on a low income. Yeah, that's why it's likely to be exclusively charitable. Is it for public benefit? Now, when you apply public benefit, please again divide it into two aspects. Start with the benefit. Is there more harm than benefit, or is there more benefit to, I mean, again, you'll have to answer that question for me. Is there benefit in having asylum seekers being given or provided some accommodation? Anissa says yes. Thanks for that, Anissa. I'm going to wait for others to chime in. Rebecca also says there's a benefit. Thanks, Rebecca. Thanks, Maxine. Yeah, I agree. I think there is benefit here, right? There is nothing to suggest that this is a detrimental endeavor. It's definitely a beneficial endeavor. Asylum seekers do, and that brings us to the next question as well, which Judy I think has already answered. Um, uh, are asylum seekers a section of the public? And Judy says yes, and I would agree with that, right? I think that there's a good case for arguing that this is met, right? So let me just break this down for you the way you would be expected to do it. The benefit aspect, right? Providing housing to asylum seekers is more beneficial than detrimental. And then the public aspect is also satisfied because of what Judy just said. I'm going to cut and paste that here because asylum seekers constitute a section of the public. Yeah, that's the answer there. And so on that basis, your conclusion would be that this trust is likely to be charitable. Note again, before we go on the go for our break here, that there are three distinct requirements that you need to apply. Quite often, students just stop here. They just stop their analysis here. They say, well, it falls within the head of charity, therefore it's charitable. No, that's not enough. You need to show it's exclusively charitable as well. And then most critically, you need to apply the public benefit test. This is very much a critical requirement that needs to be met in order for a purpose to be charitable. I'm going to go to the previous page and I'm going to give you a break now for about 5 minutes, let's say, and we'll reconvene and resume at 57 past 4. I will be here, but I might just have to rejoin the session in a minute because there's something wrong with the camera yet again. So for those of you on the recording, just fast forward to about 5 minutes from now, and we'll resume at 57 past 4. Right then, welcome back. If I could once more ask you to please use the raise hand function to confirm that you can hear me. All right, okay, great. Looks like we are back in business. So let's just move on then. We've looked at prevention and relief of poverty. We're now going to look at the advancement of education, which is another big head of charity in terms of, how frequently it is invoked. You'll see education would cover teaching in all sorts of educational institutions, but it's not just confined to just teaching. It's also going to include provision of scholarships, educational facilities and buildings, payments to teachers and lecturers, museums, libraries, zoos. It's a very wide definition that has been adopted here. If you want a case for that, I think a good one to cite is IRC and Macmullen. In IRC and Macmullen, it was held that education is not a static concept. Yeah, and that means it's a fairly wide concept. It's something that will develop and will continue to develop as time goes on, right? It's that kind of thing. And then we give you an example in your student guide from a case called Re Besterman's Wills Trust. Re Besterman's Will. Let me just put this down here for you. Re Besterman's from 1980, where the trust was for research, and it was held that a trust for research can be charitable as long as the subject matter of the research is useful and the results of the research will be published so that a sufficient number of people would benefit from it, right? So it's a wide concept. As far as public benefit is concerned, once again, it's the same two sub-requirements, right? Some identifiable benefit, and has to be for the public or a sufficient section of the public. In other words, the public aspect and the benefit aspect. Now, you will see here that the law on the benefit aspect is fairly consistent. It's with the sufficient section of the public that is where things do tend to take a bit of a turn with advancement of education, right? So public benefit, just going to write this down for a minute. Public benefit, and within public benefit, the question is sufficient section of the public, right? What does that really mean? And this is where what you actually have to apply is what we refer to as the personal nexus test, right? The idea is that if people are linked together by a personal nexus, then that will not amount to a sufficient section of the public. An example of that is Re Compton from 1945, which is there in your student guide, where a testator actually set up a trust for the descendants of three named persons, Montague, Powell, and Campbell children, three families, and he said a trust for the education of people of these three families. This was held to be, well, when you apply the test, it is charitable in the sense that it is for advancement of education. It is also exclusively charitable because other purpose mixed there. Yeah, Judy, linked by a personal relationship is a good way of thinking about it. But the reason why this was not charitable on the facts of Re Compton is because the descendants had been linked by a personal nexus, namely their relationship with three families or three individuals. So a settlor cannot set up a charitable trust to educate his own family. And there seems to be merit to that approach, because why should a settlor get tax reliefs, just to educate his family? He should be doing that at his own expense. That personal nexus test was then confirmed in Oppenheim and Tobacco Securities in 1951, where the House of Lords, by a 3-2 majority, was a divided judgment, held sort of laid down what the personal nexus test actually means. The trust in that case was for applying the income for the education of the children of employees or ex-employees of the British American Tobacco Company, and this was held to be not charitable. because again they're linked by their personal relationship with someone, the fact that they are employees or ex-employees of BAT, British American Tobacco. um, the majority judgment laid down what we now refer to as the personal nexus test, and there's two limbs to it. Please, if I could just remind you, it's always a good idea to keep that in mind. It's there in your student guide, but quite often students just tend to be a bit rushed with this, for better or for worse. The two limbs, I'm going to reproduce them here for just for the benefit of everyone. Uh, they are simply that you must not be, the class of beneficiaries must not be numerically negligible, yeah, and that the quality which distinguishes them from other members of the public or community must be a quality which does not depend on their relationship to a particular individual or company or several individuals or companies. So this is what we call the personal nexus test. Can I please remind you at this early stage that there's two limbs to it, right? And it's not enough for you to be free from a personal nexus. You must also not be numerically negligible. A good question that often arises is, what do we mean by numerically negligible? What class is too small? What class is numerically negligible? The sad part about that is that we don't actually have a magic number as to when a class of objects or a class of beneficiaries becomes numerically large enough to satisfy that test. I can give you some reference point from this case itself. The number of employees and ex-employees in Oppenheim was about 110,000. And the number of children would have been considerably more than that. So they were definitely not numerically negligible. But the House of Lords, of course, was concerned by that second limb, that the quality distinguishing them from other members of the community was actually their employment with the British American Tobacco Company. And that's why the test was not satisfied. It is not, and then Maha, that's the point I want to make here, that the personal nexus test does not apply to prevention relief of poverty. I'm going to write that down here if I can. And I'm going to shout it out in caps. The personal nexus test does not apply to relief of poverty. Yeah. And if you need a case for that, it's a House of Lords judgment actually called Dingle and Turner, where this was confirmed. In Dingle and Turner, the House of Lords actually confirmed that the personal nexus test does not apply to prevention and relief of poverty, right? This test is actually a bit controversial, but the test applies to every head of charity other than prevention and relief of poverty. There is some doubt as to whether it applies to religion, advancement of religion, but we're not going to go into that debate. It's a bit controversial. It's not settled. It's not been tested in courts, but it's thought that it doesn't apply there either. But it definitely applies to every other head of charity, every head other than prevention and relief of poverty. Yeah, poverty is sort of the exception. Poverty is given that special treatment because it is deemed to be just that bit more noble of an endeavor. Now, this gives rise to a related question that often arises, or has arisen at least in a particular context, which is with schools and fee charging. One of the questions that arose a few years ago now is whether private schools could be, could retain their charitable status and keep on getting tax reliefs when they actually charge fees. And you'll see it's not an easy question, right? It's had a political history as well, and you'll see here that the one idea that emerged is that the statutory definition in the 2011 Act requires every charity to prove that they bring some sort of tangible benefit. Many people thought that private schools would not be able to prove this, right? Because there would be lack of sufficient benefit given how exclusive they are. In fact, the people who thought this were wrong. And it still is something that you need to think about whether private schools can indeed still be charitable. But we look at a couple of key points here about charitable status and the principles that apply to bodies which charge fees, because that's the crucial issue here, if you will, right? Can an educational institution which charges fees be charitable? Now, this actually gives or feeds into two distinct sort of issues, which I'll highlight here for you. One is the issue of exclusivity, right? Are the purposes exclusively charitable? Running a business where the profits go to individuals would definitely not be charitable. But a charity can pay its staff and expenses, but any profit that goes beyond that must be plowed back into the charitable purpose. In other words, the profit must not accrue to individuals. So in the case of schools, if a school charges fees, right, and is making a profit, but it is not distributing that profit amongst the people who run the school, but is in fact reinvesting it back in the school, maybe by buying new facilities, maybe by hiring teachers at more competitive rates, etc., etc. As long as they can show that they are not retaining the profit or distributing the profit amongst themselves, charging fees and making a profit is not an objection. All right, and that's something that you have to keep in mind. As long as the profit is being plowed back into the charity. So that issue is sort of sorted out that way. The second issue is a bit more thorny. Are the people who can afford the fees a sufficient section of the public? Now, this is where things get a bit tricky, because if the fees can be afforded only by the very wealthy few, keep in mind that the annual fees of some of the top schools really are 30,000, in excess of 30,000 pounds. Are these a sufficient section of the public? That's the question, and that's the issue that arose in a case called Independent Schools Council and Charity Commission, right? I'm just going to write that down here for you. It's in your student guide as well. Why is this still highlighting? Bear with me one moment. So this is Independent Schools Council and Charity Commission from 2011. Right? When it was decided, it was a fascinating judgment because there was so much to unpack there, what the tribunal said. But I'll give you the background first. The background is that the Charity Commission actually told two fee-charging independent schools that you are not meeting the public benefit test for charitable status, and that you have to provide a certain percentage of your places for free or scholarship students. And that's when the Independent Schools Council actually brought the case forward, seeking a judicial review of the Charity Commission's guidance, right? And again, the entire question here was on public benefit. The first limb of public benefit was satisfied. There is clear benefit in schooling people, right? To have an educated population, that's not even up for debate. Whether or not it is going to satisfy the second limb of public benefit is what was in issue, right? The second limb of public benefit is that it has to be available, of course, to either the public at large or to a sufficient section of the public. And the argument laid down, or the argument addressed in this judgment was, is this excluding the poor, right? And that is something that you cannot do. Exclusion of the poor means that the body is not charitable, and hence was sort of laid down the rule that you are under, that fee charging schools are under a duty to not exclude the poor. Yeah, this is what the Independent Schools Council case essentially laid down. Now, at the time, this was, of course, quite a landmark kind of declaration, right? That if you're excluding the poor, you're not charitable. You're actually under a duty to not exclude the poor. The question is, how can one fulfill that duty? And this is where the judgment, entered into a controversial area, because it said, look, it's ultimately up to the trustees to decide how they want to fulfill this duty, but we can give you some examples. And the examples they gave were, things like providing scholarships and bursaries, having arrangements that allow students from local state schools to attend classes in in these fee charging schools, sharing teachers or sharing teaching facilities with local schools, sharing of sports fields, sharing of swimming pools, right? Things of these kinds of things, running summer schools at these for children from other types of schools. As long as you do that, according to the judgment or the decision, I should say, in Independent Schools Council and Charity Commission, that duty to not exclude the poor would have been met. The take-home point being, therefore, that although there is a duty to not exclude the poor, that duty can be discharged quite easily when you think about it, right? You don't have to actually accommodate the poor. You just have to take some measures to show that you're not excluding them. Make of that what you will. And the point is that this judgment essentially held. Maha, that is $1 million question. Are universities charities? A number of them are. A number of universities are. I mean, I know that my one of you know, I'm not going to say more about that, but a number of universities are charitable, right? Including, some parts of the University of London in particular, that comes to mind, right? They're charitable, not private ones, right? Not private ones. Private ones are, of course, businesses, and so they're meant to be run as businesses. But universities, a lot of universities are charitable, public universities at least. So that's advancement of education there. The key point about fee charging, if I could just reiterate for you, you can charge fees. That's fine. A lot of charities do charge fees. Charging fees, not a problem. Making a profit, not a problem, as long as the profit is being plowed back into the charity. So what is a problem is if you distribute the profit amongst yourselves, that's not allowed. And then if you're charging very high fees, the question to ask is, are you excluding the poor? If you're not, if you're taking measures to accommodate them, then that duty is fulfilled. That's sort of the long and short of it, if you will. The final head of charity that we have to look at is advancement of religion, right? Now, once again, you'll see that when it comes to religion, section 3, subsection 2 of the Charities Act actually defines religion. In fact, let me just give you that definition here. I'm going to cut and paste this from the Charities Act itself, right? Section 3, subsection 2, paragraph A defines religion as follows. And this, by the way, is section 31C. 31C of the Charities Act 2011. So what is religion? How is religion defined? Why is it not? There's a definition. Let me see if I can just make it a bit more legible. It says religion includes a religion which involves belief in more than one God, and a religion which does not involve belief in a God. Now, can I just give you some background to this? The first thing to focus on here is that the word here is includes. What that means, what that means is that there can be, there can essentially be other definitions to religion. This is a non-exhaustive definition, right? But when you talk about religion, anything that involves belief in more than one God will also be a religion, as will a religion which does not involve belief in a God. So where does the line get drawn? A good case to sort of illustrate where the line gets drawn is South Place Ethical Society. From 1980. Again, it's in your student guide, so I'm not going to go into the facts much, but I'll just remind you that that society was held up to actually provide a platform to discuss ethical behavior, right? It was not charitable because it was held that this is not, it was not charitable under the religion head, at least, because this was not within the spirit of religion. Religion would mean something more than just discussing ethical values and having philosophical discussions. That in and of itself would not be religious, right? So you see, the charitable religious trust would be those which actually advance religion, right? Maybe by holding religious services, providing repair of places of worship, training of clergy, distribution of publications, those kinds of things are what you have in mind. The Charity Commission generally has a very generous approach towards registering religions. And there's a case called Thornton and Howe, and again, it's there in your student guide, where it was simply held that anything that's not adverse to the very foundations of all religion and subversive of all morality will be recognized as religion. One of my favorite applications that got rejected, though, an application for getting themselves registered as a charity, was for the religion of Jediism, right? For those of you who are into Star Wars, it was the Order of the Temple of Jedi. They tried to get themselves registered as a charity, but they were deemed not to be a charity, right? Because it was held that, well, they didn't call them a cult, but they are a bit of a cult, if you get my drift here. I mean, the idea being, I'm just going to share very briefly. I think I have enough time to very briefly just share with you what I mean by that, right? Because it's an interesting one to think about. This is the website of the temple of the Jedi Order, right? And it says the Jedi here are real people who live their lives according to the Jedi Order, right? And it says the Jedi here are real people who live their lives according to the principles of Jediism, the real life Jedi religion and philosophy, and they believe in the Force and in the inherent worth of all life within it. But again, the problem here was, according to the Charity Commission, this is not a religion, and therefore they were not registered as such. Otherwise, any genuinely theistic religion will almost always be registered, and there's not going to be a problem there. Why was it not Maha? There was not a religion because it was held that, I mean, it wasn't held, actually reject the application was rejected, but primarily because it was not, didn't satisfy the definition of, furthering or advancing religious belief. These are more of, again, ethical or philosophical beliefs more than religious beliefs, right? And then they're based on a movie. I mean, they didn't appeal that decision, by the way. I think the one that does still boggle the mind is Scientology. Scientology is still not recognized as a religion for purposes of the Charities Act 2011. And that's a bit perverse when you think about it, because for all other purposes of the law, they count as a religion. So you can actually get married at a place of worship that falls within the Scientology's the beliefs of Scientologists is their place of worship, and they can constitute a chapel for purposes of registration of a marriage. Yet it's not a religion for purposes of charity law. That will probably change. Can I just say it will likely be eventually registered as a religion, but for present purposes, it still isn't. So that is advancement of religion in terms of what the actual purpose is. For public benefit, again, you'll see that as long as the place of worship is open to all, even if only a small number of people attend, public benefit will be usually satisfied. You'll appreciate I said to you that there's no longer a presumption of benefit, right? Because of section 4 subsection 2. So you have to prove that there is some demonstrable benefit to a religious belief. Now, the Charity Commission, for understandable reasons, is very generous towards this, right? Because you can't really demonstrate, benefits to religion in the sense that because it's faith, it's something that you don't know, it's something you can't really prove, and that's why we call it faith, right? You can't therefore demonstrate that it brings benefit. But this is why the Charity Commission has taken a fairly neutral stance on this, saying that, well, we're not looking at the rightness or wrongness of a religious belief. We're simply looking at whether there is benefit to be derived from, following a particular, purpose to its logical conclusion. And on that touchstone, because of that generosity, that requirement will usually be satisfied. On the public aspect, just a couple of things that I do want you to focus on, a couple of cases that are there in your student guide. So, for example, in Neville Estates and Madden, the trust was for the for the Catford Synagogue, and this was held to be charitable, even though its doors were not open to everyone. It was only open to a select number of people, right? Uh, the fact, the logic used in the judgment was that attending places of worship, would sort of be beneficial because the people who do attend that place of worship will then mingle with the rest of the public, and that will bring public benefit. So you can see it's that kind of argument here. Um, by contrast, in a case called Gilmer and Coates, which again is there in your student guide in the same section, 1949, in that case, there was a cloistered community of Catholic nuns who had no contact with the outside world. So they'd spend their entire day, all their lives literally, in that closed community, that cloistered community, and they would just pray for the benefit of mankind. Now, there were arguments made that, look, their prayers bring a benefit to everyone, right? Now, they can't prove that the prayers work, but the argument was that their lives are inspirational because they are leaving, they're leaving all material possessions behind them, and they're living pious lives devoted to the faith that they adhere to, and that this is like edification by example, but people will be inspired by someone who's devoting their life to a religious purpose of that sort. But again, these arguments did not work. The fatal factor here was that because they had no interaction whatsoever with the outside world, it just did not qualify as a religious as advancement of religion. Um, just a final thing, in your student guide, you'll see here that we do mention in E, political purposes, right? And we say to you that political purposes are not charitable. For this, you're going to have to see your reading, because I'm not going to fill this out yet. This actually comes up as part of one of the engage tasks. So when you have your workshops next week, just remind me or whoever your workshop tutor is to flag this up for you again, because as part of your reading and as part of one of the engaged tasks, you'll be looking at that question. Can trusts which have political purposes be charitable? Spoiler alert, they cannot. But why not? Have a look at your reading, and that will probably give you a good idea. Now that brings us to the final two exceptions that exist for a purpose trust. So far we've said that trusts are valid only if they have beneficiaries who can go to court to enforce them. And that means that the general rule is that purpose trusts are void because they don't comply with the beneficiary principle. Charitable purpose trusts are one of the exceptions to that rule. Now we'll see that there are also two other exceptions. They are collectively referred to as non-charitable purpose trusts, but they're limited in their manifestation when you look at it. There are two types of non-charitable purpose trusts which the law will allow, and we'll deal with them in that order. The first is trusts of imperfect obligation. The other is what we call Reed Denley type trusts, where the trust is expressed as a purpose trust, but it brings benefit to individuals. Again, just to remind you of the big picture here, these are limited exceptions to the general rule that purpose trusts are void. When you look at a purpose trust, you always start with that proposition that it offends the beneficiary principle. It's not valid. However, if it is charitable, it will be recognized, and that's where you go to those three requirements. If it is not charitable, because it doesn't meet one or more of those three requirements, then you want to consider whether you can save it as a non-charitable purpose trust. And that would require you testing against these two categories. Let's start with trusts of imperfect obligation, because that's sort of the first one here. This is a closed category that has been recognized for quite a while now, and there's only two that you need to be aware of for purposes of your course. One is trusts for the care of specific animals, care of specific animals, and the other is trust for the maintenance of graves and tombs. These are really niche exceptions when you think of it, right? I'll give you an example of it. In a case called Reed Dean, which is in your student guide, the testator wanted the income from his trust to be used for the upkeep of his 8 horses and hounds. This was held to be a valid trust, right, for the upkeep of those 8 horses and hounds. In Pettingall, the testator wanted his favorite black mare to be looked after. That trust was also valid. Now, Why are they valid? They're purpose trusts. They're not charitable. Why does the law recognize them? There's no human beneficiary. They offend the beneficiary principle. The Attorney General can't enforce them. The short answer as to why these are recognized is because these are concessions to human weakness. Courts have in the past recognized them, right? And they say that there's no, the idea is that they defy legal analysis. There's no reason why they are valid. Yet, because we've been doing it for so long, we can't really go back on it now. It's that kind of logic that courts use. In fact, in a judgment in a case called Re Endicott, Justice Harman went as far as to say that even Homer sometimes nods, and sort of his way of saying that courts made a mistake when they gave validity to these trusts. They offend the beneficiary principle, yet they are valid. But it's only those two categories, none other. That's the key point here, right? In fact, if you look at how stats come up, really, in a recent survey, a number of probate solicitors were asked how many people had asked them to set up a trust in their wills to care for a pet. Um, can you guess how many people said that they had come across such? How many percent, in terms of percentages, how many people would have said that they did come across people wanting to set up a trust for their pets? Maxine's is 70. Maxine, you're close, so it's a bit less than that. It's actually 53%. 53% solicitors reported that they had been asked to set up a trust by their clients in their wills to care for a pet. These are things people want to provide for. If you have a pet, you want them to be looked after you're gone. And there are famous examples. If you go into Wikipedia, wealthiest pets. I mean, gosh, there are people. Those pets are worth more than. I mean, I'm not going to go into my net worth, but they've got quite a lot of net worth, haven't they? Right? The idea being that these are things that people want to do. Um, when it comes to maintenance of graves and tombs, the case there that you've got in your student guide is a good one to refer to, Re Hooper, where the testator left money to his executors to use the income for the upkeep of various family graves for as long as they could legally do so. This was held to be valid, and the beneficiary, despite there being no beneficiary to enforce it, right? And as I said, there's no logical reason for why they exist. This is why they're often referred to as anomalous exceptions as well, right? Because they are an anomaly in the sense that they cannot be enforced. That's why they are actually imperfect when you think about it. If you don't mind, if we could quickly have a look at these activities here that follow, starting with activity 4, right? It's a good way of getting this, some of these things done in, to look at the structure. Let's look at this together, if we could, right? So it says Gillian McGlenn's will left £20,000 to her trustees to care for her dog Molly for the rest of Molly's life, or 21 years if shorter, and the residue of her estate to her son Paul. Paul complains that he has to look after Molly because the trustees are not using the trust money for this purpose. Can anyone apply to the court to compel the trustees to use the trust money as directed? What do you think? Thanks, Judy. Thanks, Kajal. Judy, can I just say that's an excellent answer. You'll see here, I'm just going to cut and paste that actually because I think it captures the essence of what the answer to that really is, right? No, because there is no human beneficiary. Only human beings can force trustees to carry out the trust, and there are no human beneficiaries of the £20,000. Poor Molly can't walk up to court. Even if Paul were to get the money, yeah, he can actually apply to court to get the money, but even then, nobody can compel Paul to give the money or use the money for Molly's benefit. Absolutely, Judy, it's a very good point. It's still a valid trust, but it is imperfect obligation. That is absolutely correct, right? There's no human beneficiary yet. This is a valid trust. It is the obligation is imperfect because nobody can enforce it. So the long and short of it is that these trusts of imperfect obligation are trusts that cannot be enforced. right? They're valid but unenforceable. That's just a key point that you'll have to remember, really. And if you look at the next thing here, this is activity 5. This is just to remind you that the one thing that trusts of imperfect obligation must do is that they must comply with the rule against inalienability of capital. That they have to do. They can't exist forever. And if we were to just do this activity together, I think that'd be a good idea or good practice for us. The question here asks you, are the following trusts contained in a will valid? And I'm going to have you answer this in the chat box, if you will. I give £10,000 to my trustees on trust to maintain my grave for as long as the law allows. Is that valid? Yes or no? Maud says yes. Kajal said this is valid because that wording allows, because even if the law changes, will that? Very good. Kajal, thanks for that. Judy says yes because it falls in perfect obligation. Thanks, Judy. Yeah, thanks, folks. I think you're all absolutely right here. This is a valid trust here, right? For as long as the law allows, would work. And Ree Hooper is a good example of where that happened. For the same reason that Kajal has in mind there, yeah, that the law will adapt. And a similar phrase was used in Ree Hooper, actually, and it did work. Let's look at the second one. I give £50,000 to my trustee to invest and use the income to maintain my pet tortoise for the rest of his life. I'll give you some context to this. The lifespan of a tortoise is anywhere between 50 to 80 years. Would this be valid? £50,000 to my trustee on trust to invest and use the income to maintain my pet tortoise for the rest of his life. Judy says no because it offends the rule of imperfect obligation. Judy, I'm supposing you meant the rule against inalienability of capital. Maxine says no. Thanks, Maxine. This would not work. Probably this would probably be invalid, right? So no, this would be void because it offends the rule against inalienability of capital. Note, unlike the first one, where the trust was confined to as long as the law allows, the second one does not contain any restriction, right? It's not limited to 21 years, and nor can the trustee exhaust the capital because he has to use the income, right, to maintain the pet tortoise for the rest of his life. So on both counts, this would be bad. Very good. Let's go to the final one then, the final exception that we're looking at. Trusts for purposes expressed as being for the benefit of beneficiaries. Just before we get into the activity itself, I just want to talk about this briefly with you. If you go back to activity 1, actually, I gave you an example, £10,000 on trust to encourage reading among my relatives, right? Focus on that trust for a minute. £10,000 on trust to encourage reading among my relatives. Let me bring that up if I can. When you read that declaration of trust, if you look at it long and hard, you might actually say that, you know what, there are beneficiaries to this particular trust. And the beneficiaries essentially are my relatives, right? £10,000 on trust. The one at the bottom here is what I have in mind, to encourage reading among my relatives. Why can it not be argued that the relatives would be the beneficiaries here? They are identifiable beneficiaries. They're not intended to walk off with a share of the money, but they will benefit they will benefit from the purpose. So let me just take Maud's question. The rule against inalienability of capital is only for purpose trust or all trust? It only applies to purpose trust, Maud. So the point I was making for the past 2 weeks as well was that there's a perpetuity rule or a general umbrella of perpetuity rules which prevent trust from existing forever, right? For trusts created in favor of individuals, which we've looked at the past 2 weeks, that rule that applies is the rule against remoteness of vesting, which is 125 years is within which a contingency has to vest. That does not apply to purpose trusts. For purpose trust, the rule is the rule against inalienability of capital, which is 21 years. So again, that's the distinction here. The rule against inalienability of capital does not apply to any trust other than purpose trusts. Let's put it that way. Yeah. Um, Going back to my example then about encouraging reading, this is something similar to what was actually happened in Reed Denley. Let me just write Reed Denley down here, because in Denley, what happened was, if you look at the trust declaration, we give it to you. We give you the actual judgment as well. A plot of land was transferred to trustees, and the terms of the trust was that we want you to maintain it and use it for 21 years for the purposes of a sports and recreation ground for the employees of a particular company, right? That's what was said in the trust declaration. And Justice Goff held that this trust was valid, right, for the benefit of employees of a company. He said that even though the trust was for a purpose, that purpose benefited ascertainable individuals, the employees, who had sufficient benefit to be able to go to court to enforce the trust, and therefore the beneficiary principle was not offended, right? So trusts for purposes, trusts expressed as purposes, yeah, expressed as purpose trust, let's put it that way, which directly benefit individuals by conferring tangible benefit on them, right? These are what we typically refer to as Denley type trusts, and they are outside the mischief of the beneficiary principle. Now, note how this works. Charitable purpose trusts are exempt from the beneficiary principle, right? Trusts of imperfect obligation offend the beneficiary principle, yet are valid. Denley type trusts fall outside the mischief of the beneficiary principle because they are capable of being enforced by the individuals to whom they bring benefit. The key thing, of course, being that the individuals there have to be benefit. And this is what Justice Goff did in his judgment. He drew a distinction between trusts where the benefit to individuals is too abstract or too intangible, yeah, versus trusts where the purpose is actually for a tangible, going to bring tangible benefits to people. I'll give you an example of an abstract purpose. That's Reaster, where the trust was to promote, harmony amongst, nations and newspapers, something like that. That would not fit the Reed Denley bill because there's not going to be anyone to enforce it. So when you look at a purpose trust, again, if you go from in a structured way, if it's not charitable, you could try to argue that it is a Denley type trust if fulfillment of the purpose will confer some benefit on ascertainable individuals, right? What must the what must such trusts do? They must comply with the rule against inalienability of capital, just like the others must, right? Just as the trust of imperfect obligation must as well. So look out for, let me just write this down here, look out for, well, one, ascertainable individuals who would benefit in a tangible way rather than abstract way. And then secondly, the second thing to look out for is the rule against inalienability of capital. That rule has to be applied here. In the land example, what would happen after 21 years? It's a very good example. It's a very good question, Mahad. Presumably, the trust will come to an end and the money will be given to the beneficiaries or would be resettled in terms of the trust deed created by the settlor, right? So the money would therefore revert to either the whoever is nominated in the trust instrument. Let's have a look at activity 6 then to finish this off. Which one of the trusts in the following table is void for offending the rule against inalienability of capital. Let's look at the first one. Land was given on trust to be maintained and used as a sports ground for 21 years for the benefit of employees of a company. Is this valid or void? Judy says valid. Thanks, Judy. I'm going to wait for others to also chime in if they can. Mahad says valid. I'm going to wait for others as well. Thanks, Mahad. Maxine says valid too. All right, we're getting there slowly, but yeah, this would be valid, right? Because you will see. Thanks, Anisa. You'll see that because it is expressly limited to 21 years, right? So that would not offend the rule against inalienability of capital. Let's look at B. I give 1.25 million pounds to be spent on building a gymnasium for use by employees of Rafters and Co. Limited. Is this valid or void? Judy and Maxine say valid. Thanks for that, folks. I'm going to wait for others. Mahad also says valid. All right. Again, you are absolutely correct. This is valid because even though it is not confined to 21 years, why is it valid? Because the trustees can do what? If it's not confined to 21 years. Yeah.
Sorry, are you asking for B?
Yeah, for B.
It's valid because although it's not conferred to 21 years, the trustees are able to spend the capital at once.
Yeah, very good. Thanks for that, Judy. That's absolutely correct. Thanks for that, Mahad, as well. They can spend the capital in one go. That's why this is valid. And then finally, I give 1.25 million pounds to be spent on building and maintaining a gymnasium for use by employees of Rafters and Co. Limited. I mean, is this valid or void? Thanks, Maxine, Mahad, Judy. Yeah, this is void. In this case, it's void because maintaining is a recurring expense, thus rendering capital inalienable. That's why it is void. So you'll see here that these are all Denley type trusts, but only the first two here would have been valid because they complied with the rule against inalienability of capital. This one here did not comply with the rule against inalienability of capital. That's why it would have been void. Now, can I just say very quickly, I know we haven't got a minute left, that we do give you a flow chart at the very end of your student guide. If you don't mind, I'm going to pull that up right now, actually, because we will be doing this in the workshop in a lot of detail, so you'll be fine there. But just have a look at this flow chart here. This gives you a good structure of how you're going to proceed. Once you've identified a purpose trust, right? You're going to explain the general rule and then try to fit it in one of the exceptions. Start by looking at whether it's charitable, apply the 3 criteria. If it is charitable, then it is valid as a charitable purpose trust. If it is not charitable, don't stop your analysis there. Consider whether you can save it either as a Reed Denley trust or as a trust of imperfect obligation, right? And if you're looking at one of those things, then of course you have to apply the rule against inalienability of capital, as well as looking at the certainty of objects. If none of the exceptions work, the trust is void because we go back to the general rule. Maxine, this is at the very last page of your student guide. And not the last page, actually, it's at page, let me see, page 14 of your student guide. And for those of you watching on the recording as well, this flow chart is at page 14, right at the very end. Yeah. So I'm going to stop the recording now, and I'll see you all